10.
Thank you, my lords and my lady. Yes. In the interest of justice and time, I do not need 10 minutes. I only need 4.5 minutes. Yes. My lords, my lady, my learned colleague, Degwa, has submitted exhaustively. So, I will only be enumerating the reliefs sought. My lords and my lady, at the heart of this petition lies the doctrine of popular sovereignty, as codified under Article 1, which vests the sovereignty or the sovereign power in the people of Kenya and permits its exercise either directly or through the democratically elected representatives. My lords and my lady, the office of the Deputy President is not an appointed or technocratic office. It is a direct product of a universal suffrage, deriving its legitimacy from the will of the electorates expressed at the ballot. It therefore follows that any process that seeks to remove a deputy president from office must be approached with heightened constitutional sensitivity and restraint. It implicates not merely the tenure of an individual office holder, but the sovereign will of the people themselves. Therefore, as a result, and culminating from our submissions, we have sought the following reliefs. 1, a declaration that the impeachment proceedings against the Deputy President were conducted in violation of the Constitution of Kenya and were therefore unconstitutional, null and void. Number 2, a declaration that failure to apply the modification framework under Article 152, read together with Article 144 and 145, as required, rendered the entire impeachment process fatally defective. C, a declaration that the proceedings violated the petitioner's right under Article 52A, as well as 26, 28, 48 of the Constitution. D, a declaration that the Senate acted in breach of its own standing orders, including standing orders number 75, 78, and 80, thereby rendering the proceedings procedurally ultra vires. E, an order of certiorari quashing the impeachment decision and all consequential actions arising therefrom. F, an order of prohibition restraining the implementation, enforcement, or further reliance upon the impugned impeachment decision. And lastly, any other consequential or auxiliary order that this Honorable Court may deem fit and just to grant. Thank you very much, my lords and my lady.
Thank you.
Your Honor, I'd ask for 15 minutes. I'll try to maintain that. I acknowledge that I see I'm the last petitioner. It's based on, I believe the petitioners are really exhausted and have given admirable, so their submissions with admirable force and clarity that I feel like I'll only be doing closing remarks because they have almost said everything.
Please tell us your name.
I'm Momanyi for the 58th petitioner.
15th.
58th petition.
Yes.
Yeah, 58th.
They are not here.
Yes, Your Honor. Your Honor, we do rely on our petition, which is dated the 18th of October 2024 and amended on the 23rd of October 2024. Our submissions are also dated, our submissions and list of authorities dated the 2nd of January 2026. Your Honor, I'll seek not to traverse grounds that have already been submitted upon by my fellow petitioners. I'll only seek to maybe highlight or underscore cardinal aspects that I think maybe have not been mentioned or have not been given in the flavor that the petitioner herein may have wanted to do. Your Honor, we do submit that, looking even at our submissions, we submit that this impeachment does rest on one singular but profound constitutional question. And simply, this question, which relates to the issues that we put before this court, is whether the impeachment of the Deputy President, the former Deputy President Rigathi Gachagua, His Excellency Rigathi Gachagua, was conducted in accordance with the Constitution, or whether it represent, or whether that impeachment process only represents what we term as a fundamental misapplication of constitutional power. In our submissions, we submit that the impeachment process in its entirety is a definite misapplication on constitutional power. And when we speak to constitutional power, we do rest our arguments on Chapter 1 of the Constitution of Kenya. Article 1.1 of the Constitution of Kenya does state that sovereign power belongs to the people of Kenya and shall be exercised only in accordance with that Constitution. And when you read that provision, Article 1.1, we are reading it together with Article 1.3, which provides on how this sovereign is to be exercised through delegated power. And this delegated power has been delegated to the three arms of government. And in our submissions is that the parliament violated this power that has been given by the people. And we say that when delegated power, which the parliament wielded so capriciously for political convenience against the very people from whom that power was given, that exercise ceased to be constitutional governance and only descended to be constitutional betrayal. And you see a parliament that indeed betrayed the sovereign power that has been given by the people and conducted an impeachment process that is not only unfair, but also an impeachment process that gravely violates very many provisions of the Constitution. In our petition, we quoted 20 provisions of that Constitution. The petitioners that have come before me have listed a lot of those provisions. I wish not to repeat. But only in summarizing my arguments under Article 1.1, I seek to remind this court of the quote by Justice Emeritus Chief Justice Maraga, when he said that the greatness of any nation lies in its fidelity to the Constitution and adherence to the rule of law, and above all, respect to God. And we also submit that the only way to preserve the rule of law is to apply it equally to everyone. And many petitioners who have come before me, they have said that the impeachment process fell well below the standard of the Constitution. Your Honor, this impeachment process, as it is, opens a constitutional backdoor to power. It provides an alternative way in which the direct vote of the people has an alternative whereby we can easily impeach a leader who has been validly elected by the people through such of a sham of an impeachment process. And we urge this court to shut this door, because this impeachment, the way it was done, it puts the country at a very bad position, and as it has only left a constitutional backdoor to power which we submit should not be allowed, as it will be an alternative pathway to electoral process, which is the direct power of the people, which is provided under Article 1. On fair hearing, Article 50, I wish not to dwell on this because the petitioners before me have really exhausted this ground. But I wish maybe to remind, I remember when my senior, Mr. Ongwea, was presenting his submissions before you, he listed 3 trials that he termed as predetermined trials with unfair outcome. I do not know the 2, but I know at least the trial of Jesus Christ. And I say in my humble submission that at least with the trial of Jesus Christ, Jesus was given the opportunity to be heard in this impeachment process. It really, when you look at it, and you look in a constitutional democracy of the 21st century, such as Kenya, with a constitution that is celebrated across the globe, with a constitution that has fidelity to human rights and due process, you can really make a conclusion that this parliament sank very low. Even when you look even at the conduct of the speakers of both parliament, and I also relate it to the trial of Jesus, I say that at least Pontius Pilate washed his hands when he saw that people could not move. But when you look at the Senate, instead of calling the House to order, they prevailed even to vote. Like the Speaker of the Senate went ahead to put a vote on whether someone's constitutional rights of a fair hearing should be respected. Your Honor, Article 50 contains rights that are not only inalienable, but also non-derogable. And that was a great violation of the Constitution. Your Honor, I seek to move to Article 145 and 150. And the petitioners who have come before me have made arguments both on the threshold and the process. And they have submitted that this process failed in both, not only in process, but also in threshold that is required by the Constitution. When you look at process, and I submit on Article 145(3), they made very many distinct legal arguments on whether it is a discretion or the Constitution requires that there must be a special committee. Your Honor, I'll only argue on English, plain English, even literal rule in interpretation of that provision. Your Honor, when you use the word may and you add and, you remove it as an option. When you say, for instance, I want to see, may I see John and James? It is either you see John and James or you don't. And I submit that that may that has been put there is only functions whereby the Senate may not proceed to impeachment. There might even be a preliminary objection, notice of objection on the floor of Parliament, maybe something that has emanated from the National Assembly that prevents even the Senate itself from proceeding to impeachment. But we submit that as per Article 145 and 150, there must be a special committee for investigations. On the aspect of threshold, the Constitution is very clear. It uses the word serious, it uses the word gross. Your Honor, these words are not ornamental. They have a purpose. The framers of the Constitution put them there for a particular purpose. And by use of those terms, it means that there are offenses that are impeachable, and there are also other offenses that are not impeachable. And as such, we submit that none of those charges met the threshold. And I'd like to maybe dwell on the common ground, the issue of shareholder. When you look at the mover of that motion, there's nothing he presented apart from the argument that when the deputy president was talking about shareholder, those words were divisive, those words were inciting the public. No other evidence was brought in Parliament. Your Honor, what this mover wanted is that he put himself out as an authority to tell the Parliament, both houses of Parliament, that the term shareholder is inciting. The term shareholder is divisive. The term shareholder is against the National Cohesion and Integration Act, without even the institutional backing of that body, which enjoys public money, taxpayers' money, for it to act. Even the Senate did not proceed to conduct investigation so that they can establish these words divisive, as the National Cohesion and Integration Commission deemed it as insightful and divisive. We submit that it lacked authoritative and institutional support. So it was just the words of the mover of impeachment. I believe we dwell on the Latin phrase of ipsi dixit, which simply refers to somebody, a speaker, simply telling people that, believe me, I'm the authority. This is what I mean when I say that these words are divisive and insightful. On Article 152.
Council, you're in your last 2 minutes?
Yes, I'm finalizing. Yes, a minute.
Minute and a half.
Yes, Your Honor. Yes, my lady. Your Honor, as I finish on Article 152, the petitioners who have come before me have made valid arguments on that provision. I'd seek not to go deep into the legal aspects of it. I only seek to direct this, my lords and my lady, to the Senate Hansard on the 17th of October 2024. I see Mr. Ojenda has been, Professor Ojenda has been attacking petitioners for mentioning Sifuna. Let me make a change and mention Okia Omtata. And Mr. Okia Omtata, these words, even if these words are adequate to prove that this provision was violated. He says that I stand here to look at whether the House has complied with the Constitution, and he mentions Article 152 on removal of the Deputy President from office. And he makes similar submissions to what my senior, Mr. Ndego, has made, that the role of a Deputy President is derivative. So when you move to impeach a Deputy President, you must acknowledge that aspect. And he says that these modifications have been couched as a mandatory. So when you're making impeachment of a Deputy President, you must do the necessary modifications. Your Honor, I will not proceed to, I will rest at this position. My prayers are similar to what other petitioners have prayed for because of time. I'll not proceed to mention and rest my submissions at this position. Thank you very much.
Thank you very much. We have come to